Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3039, United States of America versus Yvonne Lamont Robinson, appellant. Mr. Mestiz for the appellant, Mr. McGovern for the appellate.
Good morning, counsel.
Good morning, Your Honor. With the court's indulgence.
Yes.
Good morning, and may it please the court. Michael Mestiz of Williams & Connolly for appellant Ivan Robinson. I'd like to reserve 2 minutes of my time for rebuttal, and I'll keep my eye on the clock. I'd like to focus my time today on the Brady violation. The government admitted below that, quote, the crux of this case, and, quote, the only element in dispute was whether Dr. Robinson was prescribing medications in good faith. An essential part of the government's theory was that when Dr. Robinson threatened to report pill-seeking patients, he was, quote, just putting on speeches, but didn't turn any of them away. But the government failed to produce information from its own files showing that Dr. Robinson was telling the truth. This evidence was directly inconsistent with the government's theory of the case, and its suppression was material. Dr. Robinson, in fact, knew that this information would be essential to his defense, and so he repeatedly requested from the government records of his reporting pill seekers to authorities. In response to his requests, the government repeatedly told him that no prior reports existed, reversing course only after trial. And it failed to disclose a detailed CCN report of an incident in which Dr. Robinson detected a pill seeker, reported her to authorities, and took the prescription back in the police's presence. Now, the district court correctly recognized that these reports were favorable to Dr. Robinson, but the court erred in concluding that they were not material. The suppressed reports would have been powerful evidence that Dr. Robinson engaged in good faith treatment of his patients, that he was not, as the government suggested, knowledgeable that his patients were pill seekers, but somehow complicit in prescribing the medication.
The district court's take on materiality, and this is perhaps going to be a quibble rather than an analysis, is that the case was so overwhelming that this could not have made any difference. Now, while that might perhaps be styled as a harmless error decision rather than as a materiality of withholding decision, why isn't that correct? This is a pretty overwhelming case, wasn't it?
Well, Your Honor, my first response there would be that this court and the Supreme Court have been very clear that the Brady materiality analysis is not a sufficiency of the evidence analysis. So the question is whether in any reasonable likelihood it could have affected the judgment of a jury. The defendant, and this is weary, need not show that he's more likely than not to have been acquitted. I think Johnson, quoting Kyle's, this court's opinion, says, would the evidence have resulted in a markedly weaker case for the prosecution or a markedly stronger one for the defense? And that's the case here, Your Honor, to get directly to the record. The government was able to tell the jury below, Dr. Robinson knew these patients were pill seekers. He never reported them. And in fact, the suppressed evidence would have been powerful extrinsic evidence, corroborating evidence that he did. And so in Ray Seald's case, this court found that corroborating evidence when the government calls into account testimony is material. Long v. Hooks, the recent Fourth Circuit case, I think is also highly on point here. Now, I will say with respect to the rest of the evidence in the record, there is evidence from patients that, for example, they felt they had to lie to Dr. Robinson in order to get their prescriptions.
Now, his prescriptions, was it routine that he gave a 30 milligram prescription for?
Your Honor, that was part of his patented protocol, and in fact,
the answer would be yes then, right?
The answer
routine that he gave 30 milligram.
The answer would be yes.
And 90 pills in a prescription?
Your Honor, I believe that is correct, although I'm less certain about
and the prescriptions were so large in quantity and time that the pharmacists were alarmed enough that they alerted authorities. Is that not also evidence?
Certain pharmacists testified to that, although they did not tie that to any
And
convictions.
he insisted on being paid with money orders, blank money orders. Why was that, counsel?
Your Honor, that's not unusual, and witnesses testified it's not unusual. These are people who don't have insurance or whose insurance does not cover this. And so, I think the government has kind of pursued a guilt by gestalt theory here, the idea that, well, they're not familiar with what this practice looks like. In fact, I think the factual record as laid out in our briefs are quite complex, such that, in particular, this suppressed evidence could very reasonably have swayed a juror in considering the critical issue here, which is mens rea. And I think Ruan underscores that. This court and the Supreme Court have been particularly attentive in questions where intent separates innocent from wrongful conduct. The question of intent is incredibly important, and the government conceded that below. So here, the suppressed reports would have shown that when Dr. Robinson was aware of pill seekers, he reported them. That leads to a very strong inference that he was not aware that the patients charged in the indictment were merely seeking pills. And indeed, each of them had actual injuries. Each of them, at Dr. Robinson's request, brought in MRIs. And, there's testimony that he followed up with them to ensure that they were following the treatment protocol. The government's
There is some gestalt to the government's case, but there's also a fair amount of proof of individual instances, right? There are 40-something counts which are supported by testimony from the undercover agents and the pill seeker patients about what happened in their individual cases with minimal consultation and the like.
And Your Honor, I don't think that the court should be concerned about that. I have two primary responses. The first response is that the government goes out of its way to say, well, patients' views about whether or not they were adequately treated is irrelevant. We don't need to consider that. All the evidence in the record shows that the straight leg test, which is the standard diagnostic test, doesn't take very long. The other thing is that the government pursued really a wholesale theory, right? Their wholesale theory was this entire thing is a sham. And so I think the government's central issue.
I guess it seems to me they pursued both.
Okay.
Wholesale and retail.
Well, and I think then their theory as to mens rea, for example, is that all of this was a sham, right? They didn't claim that, well, he knew certain people were pill seekers. He didn't know other people were pill seekers. That's kind of the suggestion on appeal that they make as to why, some of these reports might not have been material.
Assuming the government's theory, why does the government's theory have to be that all of them were shams in order for it still to be a sham there that is a violation?
But Your Honor,
you're repackaging the theory, and it's not necessary that he could also have legitimate patients and still be violating the statute in the instances that were pill seeking.
And Your Honor, the government certainly could have argued that to the jury, taking this Brady material into account. The problem is that argument is substantially more complicated than the theory they were permitted to advance to the jury.
I don't see the complication.
Well, so think about...
You can't deny that there have been medical professionals around the country who were medical professionals with legitimate patients who were nonetheless convicted of...
I don't deny that, Your Honor, but that's not...
That's not very complicated, counsel.
Well, the government here came in and they said, look, he knew all of these people were pill seekers. This was a classic pill mill. There was no treatment here. He never reported any of these people. They suppressed evidence showing that he, in fact, did report pill seekers when he was aware of them. And so the government could have argued...
But there was some evidence to that effect that was not suppressed, right?
There was the DEA report, which is incredibly bare bones. And you can think of the DEA report as focusing on the pill seeker. The CCN report, which is suppressed, focuses on what Dr. Robinson did to detect. And that was not disclosed. That's at A189. There's a little paragraph that, contrary to what the government said, Dr. Robinson checked the referral, he detected a pill seeker, and then he actually took his prescription back in the presence of police. And I see I'm running into my rebuttal time. I just want to squarely answer Your Honor's question, which is that the government was able to come in and say he never reported anyone. Now, in fact, had this evidence been in the record, the government would have had to come in and say to the jury, well, okay, he reported some people, but he did so only as part of this scheme and to throw people off the scent, and he knew other people were pill seekers, but he didn't report them. And that is a substantially harder inference for the government to prove beyond a reasonable doubt. And that's why the Brady evidence is material.
It seems to me like both sides here were trying to have their cake and eat it too, because the government was just prosecuting the particular prescriptions at issue, not arguing or trying to prove to the jury that the entire practice was corrupt. And the evidence that you're arguing is material didn't bear on the prescriptions or patients at issue in the indictment. It dealt with other ones. And so it seems to me at this point, the defense wants to have the broader view. But at many other times during the trial, the defense was arguing to limit the evidence to these prescriptions and these patients that are charged. And so, and the government at times did certainly seem to be trying to have a broader inference, that both were trying to go large and small. But given that the indictment involves specific individuals and specific prescriptions, and this Brady evidence, and at least as I read the government statement to which you refer when he said never reported any of these persons, it meant the people in the indictment, which is accurate. They were never reported, as I understand, as pill reporters. And so now so help me understand one more time how then it's material that he reported other persons. I mean, I get your argument about why the DEA report and the CCN report are so much more valuable the CCN report is so much more valuable, but it wasn't speaking to the people at issue in the indictment. And that's what the government statement was about, and that's what the case was about.
Well, Your Honor, if I may briefly respond, the fact that he reported other pill seekers when he detected them strongly suggests that he did not know these individuals were pill seekers. And that weakens the corresponding inference from the government that he was knowingly and intentionally prescribing these medications outside the course of ordinary medical practice. So it's true that the individuals in the indictment he did not report, but the fact that he reported other pill seekers when he was aware of them gives strong evidence that these pill seekers successfully deceived him.
Were these other pill seekers, for example, in the CCN report, reported in the same time frame as when the indictment is covering those patients were being treated, or was it?
Yes, Your Honor. So there are two sets of suppressed reports here. The prior reports were from 2011. The CCN and DEA reports, I believe, were from 2013. And in fact, that entire period is at issue. The district court erred below in saying that 2011 was somehow removed from time, and I don't really see the government defending that conclusion on it.
But the CCN report, one that has language you most like about Dr. Robinson's practice, that one was during the same time frame as charged in this case?
Yes, Your Honor.
So while he was treating these individuals, he was reporting pill seekers simultaneously?
Yes, Your Honor. And indeed, in 2011, he was also treating one of the patients charged in the indictment. So that 2011 period is relevant as well. I see I have run through my time.
We'll give you some time for rebuttal.
I appreciate that, Your Honor.
Any more questions?
Just one more, which is when we assess materiality, we have to look at counterfactually at what would have happened had the material been disclosed. And part of that is you get to put in the prior reports and make the arguments to the jury that you've made here. Part of that is also that Agent Pryor would have testified that she thought this reporting was a sham. Doesn't that tend to mitigate the impact of what you could have done had this been disclosed?
So, Your Honor, that's certainly what the government proffers would happen. Terrific question for the jury. Quintessential question for the jury. Not something that this court should evaluate on appeal, but if the government wants to go in and argue, well, he knew some people were pill seekers, he didn't report them, he knew other people were pill seekers, and he did report them, all of this is part of kind of an increasingly elaborate scheme. They can argue that to the jury, and the jury can weigh that in the first instance. But I think that's not a reason to find this evidence immaterial as a matter of law. Thank you.
All right, thank you.
Good morning. May it please the court, Michael McGovern on behalf of the appellee of the United States. Over the course of nearly a month, a jury was presented with evidence from the government and from Nurse Robinson regarding his treatment of 10 individuals, prescribing them on 43 occasions oxycodone. Evidence that included testimonial eyewitness accounts that Dr. Robinson had reported a pill seeker and called the police on those pill seekers. Testimonial evidence that included testimony by his office manager that Dr. Robinson kept a file of bad actors and was attempting to track individuals who were pill seeking. At the conclusion of all of the voluminous evidence, the jury deliberated, considered the arguments of both of the parties, and determined beyond a reasonable doubt that on 42 of the 43 occasions, nurse practitioner Robinson prescribed oxycodone intentionally and knowingly in violation without a legitimate medical purpose and outside of the course of the usual practice of business.
The evidence of reporting the pill seekers that came in was from his side of that transaction, and you all attacked that as coming from self-interested and biased witnesses.
Well, Your Honor, I'd like to correct that a little bit. Yes,
Okay.
both of the statements of pill seeking that were introduced were by witnesses that Dr. Robinson presented. One of those
Whose credibility you questioned, right?
We questioned the credibility of his office manager given his incredibly close, but in closing arguments, the credibility of Dr. Erica Brock, who was an individual who testified. She was present when there were reports to authorities and authorities arrived at the office in response to those reports. Her credibility in closing argument was never contested by the government. And the government
Does that matter? I mean, the government argues in fora after fora that official records, official statements, official communications by the government have particular force. And so whether it was a witness that you had a lot to impugn or not, it was his witness. And the value of this report, or the reports, all the reports at issue here, particularly the CCN report, was that it was the government recording and describing what he did.
Well, Your Honor, that was a strategic trial decision that was made by defense counsel that they're now second guessing.
Wait, I'm sorry. I think I wasn't clear. What strategic trial? This is suppressed information.
The defense counsel had access to government reports of a pill seeker.
It had a DEA report. It said the CCN report details exactly what he did. And I'm just to step back for a second. Are you trying to have this court hold that the government doesn't have to turn over its own documentation in this situation?
No, Your Honor, the government hasn't contended either that the CCN or the prior reports were not favorable and were not disclosed late.
Why were they not disclosed? How did that happen?
There's no explanation on the record as to why the particular CCN report was not disclosed. We will note that the information in the CCN report and the incident to which the CCN report related was disclosed in the DEA-6, which is a much more extensive document.
That's not answering the question as to how it could happen that you didn't turn these over. That the presiding judge just asked you, you're not arguing that you didn't need to turn those over. Going back with the Stevens case and before, we have told the government repeatedly that don't you be making materiality decisions if it's evidence that's relevant, turn it over. But why was that not done in this case?
Your Honor, it wasn't done in this case because the government, the prosecutors that were providing the discovery, weren't aware of the reports. They did reach out to Agent Pryor, and when they first spoke to Agent Pryor, her response was that she didn't believe that she had any reports from the incident that was discussed. It wasn't until later when Agent Pryor recalled that there was another individual present at the debriefings, that they contacted that agent and he was able to locate the reports. The reports weren't filed.
Sorry. When agents make reports, that's like one of the biggest things they do. And so when there was said this known contact, this known communication and interchange, and a DEA agent says, I don't think there was a report. The prosecutor goes, okay, there's no records. You don't say go search the records. Who else was at the meeting? It just seems to me confounding that you have the 2 prior reports and the CCN report, which you want to blame them for not having found. And yet the government didn't do any due diligence, it seems. And unless I'm happy to hear you tell me otherwise, but how it did, I think I'm asking the same question as Judge Sentelle.
Yes, Your Honor.
How on earth does this happen? And then it's found, surprise, right after trial, when one normally isn't doing discovery.
So, Your Honor, to answer your question, there's an extensive discussion of what efforts the government undertook to locate these reports in the record, and that appears at A199. It is the filing that the government submitted when it provided the prior reports, and it details the numerous discussions that were had and the numerous efforts, including the search of DEA files, that were undertaken and how it was.
Okay, I thought you told Judge Sentelle it wasn't in the record what happened. So now you're telling me there's a long record explanation of why they weren't turned over?
The prior reports, Your Honor, yes.
Mm-hmm. But I'm talking about the CCN report as well, all 3. I just want to be clear. You're saying PRYOR and not right prior reports.
Prior
right?
reports.
Yeah.
Yes.
And but there's also the CCN report, which is the one that they're most interested. I mean, none of it should have been suppressed. But
and Your Honor, the government is not.
What's the explanation on the CCN report? Is that the same one?
I'm sorry, Your Honor.
What is the explanation on why the CCN report wasn't turned over?
Your Honor, the record doesn't indicate specifically why the CCN report was not turned over prior, only that it related to an incident that the DEA-6 was provided. And the DEA-6 provides extensive information about the arrest of the pill seeker and the fact that arrest was based on the knowledge that MRI that they presented was fraudulent. That information is contained within the DEA-6.
It's not the same. I understand you've got the argument he had the DEA-6, but they've got a very, at least to me, important argument that they needed that the CCN report had independent value. And the government has no explanation. It was found later, right? After trial?
Yes, Your Honor.
How was it found then, but not earlier?
And again, Your Honor, the record doesn't indicate precisely how the CCN report was found, but the issue here. Can
you understand why that's really troubling? At least to me, I can't speak for my colleagues, but that's deeply troubling to me that it's not found pre-trial.
Yes, Your Honor.
You had a DEA report too, and we're aware of it. And then suddenly it appears after trial, and nobody's given any explanation at all.
Your Honor, when this issue occurred, the government argued and the court found that there was no ultimate Brady violation, which is the issue on appeal, which requires that these reports be material in order to grant the remedy of a new trial, which means that this court must find that the suppression of this report.
Sorry, my question was, do you understand why we find it quite troubling?
Yes, Your Honor.
And so what is the government doing to prevent these errors from happening again? This is, as Judge Sentelle pointed out, we've been warning the government for quite some time about the terrible consequences. And this is a case where the jury acquitted on one charge. So we have to do our job post hoc. The whole point of Brady is that the government's supposed to do this up front, not make a materiality analysis pre-trial, and just turn these things over.
Your Honor, I apologize if I gave you the impression that the reason they weren't turned over was because there was a pre-trial materiality determination by the government. That was not the case.
That's what we're worried about.
That
is part of what we've been saying, as I said, in the Stevens case, but backward, even when I was a district judge in another circuit, that you don't have to decide the materiality. That's something that can be seen by the defense and the court. If it's merely relevant, why do you not turn it over? What's the downside to going ahead and complying with your obligation?
And, Your Honor, what I'll note is that the district court here found that the government had performed a diligent search. This was not an issue of the government locating reports, determining they were not material, and not turning them over.
I thought you just said that was with respect to one of the reports. That there was a pretrial materiality determination. Didn't you just say that?
No, Your Honor. There was not a pretrial materiality determination with respect to either the CCN or the prior PRYOR reports. What I will also note, evidence that there was a diligent search by the government includes the fact that they did turn over multiple hundreds of pages from the St. Mary's County Police Department concerning the very investigation that the prior reports deal with.
That may be enough to make this, together with everything, enough to make this a harmless violation of the Brady, harmless error on your part, but I don't like the sense that the government is still trying to make materiality determinations and withholding evidence. Some states now have actually passed open file statutes requiring the state to quit attempting to withhold evidence based on their own materiality determination.
Your Honor.
We don't have that statute. I'm sorry we don't have it, but we don't have that statute. But why isn't that the way to proceed? If the government's got it and it's good evidence, what's the downside to letting the defense have it?
Yes, Your Honor, but I'll note that even an open file discovery policy, were it instituted in this case, would not have discovered the prior reports. The prior reports were not contained within the same file for Dr. Robinson. They weren't saved. They were under a general file. This had been a report that was made in 2011.
I think Judge Sentelle is asking about the CCN report.
Yeah, what about the CCN?
The record doesn't indicate why the CCN report was not located. The CCN report was a Metropolitan Police Department report concerning something that a federal DEA 6 had been turned over on, listing all of the officers that were, listing the majority of the Metropolitan Police Department officers that were involved in that case.
Can you tell me how it was found after trial?
I'm sorry, Your Honor?
Does the record show how it was found after trial?
No, Your Honor.
The government, when it finds this thing after trial and turned it over to the defense, as it should have, didn't offer any explanation as to why it didn't find it beforehand?
Your Honor, in the record, as I have read it, there is a passing reference to the fact that there had been a DEA 6 that had been turned over, and that in addition, we were now providing a CCN. There's not an extensive discussion in the record of that. But if I may briefly make one argument on the materiality prong, this court, in order to grant a new trial, does have to find that this was material.
Yes.
And the Robinson has argued that it was material because he was not in possession of government reports that showed that he was doing pill seeking. This is why he claims this was different in fact from the evidence that he was able to introduce. And the fact is, he was in possession of multiple government reports concerning both his discussion with St. Mary's County of prescription fraud investigations that were ongoing, which were the subject of the prior report, that it chose not to use. And it was in possession of a DEA 6 report, specifically on the 2013 pill seeker that was arrested, that it chose not to use. Perhaps because in that same DEA 6 report, the description of the treatment of that patient accorded with every other patient's treatment, which was that she was not interviewed by Dr. Robinson. But
they argue that the CCN report described more fully the nature of Dr. Robinson's practice, how his process of identifying the problem with the one that was the individual that was reported, and this reporting was happening at the same time that the government was saying he doesn't turn over pill seekers, at the same time as the individuals that are the subject of the indictment. So it shows that at the very same time that he's being accused by the government of not turning over pill seekers, he was doing so, and because good faith medical practice is the whole issue here, he was doing it as part of a protocol in his practice. this. And so that's where it's both the timing and the nature of the description, which you don't have from DEA-6, that for me is the most difficult part of evaluating materiality in a case where the jury was very discerning and didn't convict on it.
There are two responses. The first, as you noted to my colleague, the government's argument was that he did not report any of the individuals in the indictment. Their closing argument was not based on the fact that he never reported pill seekers. Second, I would note that the materiality that is presented by Robinson is that the CCN report would corroborate from a government source the testimony of the eyewitnesses from his practice that testified about his robust practices in reporting pill seekers. And the DEA-6 would do that, and yet they chose not to introduce it. This is at page
It wouldn't do it. They say with the amount of information focused on his practice. One focused on the person, this one focused on his practice. I mean, do you agree that the content of the two reports is different?
I agree that it is different, Your Honor.
And do you agree that the CCN report had a governmental description, a law enforcement description of the practice of how his practice identified the person that they were reporting, found the problem?
It had a governmental recitation of what Robinson said regarding how he found the problem. But if I may point, Your Honor, to the DEA-6, this is at page 181 and 182 of the record. The DEA-6 specifically states that officers were informed by Robinson that he had a person there who was, quote, doctor shopping. And then paragraph 7, Reed was questioned about the MRI she presented to Robinson that made Robinson call the police and report her. It also notes that Reed stated West, which was her cohort, made and printed the MRI from her home. So there was information that the MRI was fraudulent. There was information that MRI was provided to Robinson. There was information that the reason Robinson called the police was because of the MRI. And there was a statement that Robinson reported her as a doctor shopper. Those all corroborate the eyewitness testimony of his employees. And this DEA-6, which was in the possession of the defense counsel, wasn't introduced at trial. They never attempted to. And so it undercuts their argument that the CCN was so material as to change the outcome of the trial, that it would lead to a reasonable probability when they had the ability to corroborate. If that was necessary, they had the ability to do it, and they didn't. And that simply undercuts their argument on material. If this court...
One fact that's bothering me a little bit. Now, you have a lot of good facts on the gestalt, the standardized nature of the prescriptions, some of the entries that look in the records that look a little bit dubious. But one, I think, pretty powerful fact for the defense is this doctor secured a United States patent to treat patients with a particular mechanism. It's a device he invented. He's got the whole protocol. It includes use of painkillers. I mean, that seems pretty different from just a normal pill pusher. And I don't know, doesn't that make this a closer case and then put more pressure on materiality?
I don't believe so, Your Honor. I think that it's important to note that the patent is not a medical approval of Dr. Robinson's.
But it suggests a legitimacy and that there's substance to the practice.
Well, a patent granted him exclusive rights in that process, but the patent itself doesn't speak to the medical legitimacy of that process.
Well, maybe not objective medical legitimacy, but the question in this case, I'm sorry to jump in, is good faith. Good faith.
Right.
And so he believed he had a system. The patent well documents that. I'm sorry to jump in on your point.
Well, according to the patent document that's in the record, and it's in volume 1, I don't know precisely the page, the oxycodone prescription part of the patent only calls for 5 days of treatment. And so it actually doesn't accord with the 60 pills of 30 milligrams of oxycodone that was being provided to these patients time and time again. And so I don't believe that simply having a patent, although it may lend an air of legitimacy, the jury heard about that. The jury heard all of these points, including that Dr. Robinson's practice had a bad patient file, including that Dr. Robinson had at times reported bad pill seekers. They took all of that evidence, weighed it, and said they still did not believe on 42 occasions that that Dr. Robinson created a provider-patient relationship sufficient to prescribe oxycodone on those occasions.
Can I just ask one question, and if you don't know, that's perfectly fine. But did the jury instruction in this case comport with Ruan from the Supreme Court's very
Yes, Your
strict?
Honor. And this wasn't an issue that's been briefed.
Yeah, no, I know that's fine. If you didn't know, I was going to say it's okay. I was just curious.
I will just direct Your Honor to the jury instructions themselves. And they appear with respect to the distribution counts at page 5,112 of the transcript and continue to page 5,115. And there's also a standalone document of the jury instructions, which is at page 129. And the third element, as was
The authorization
presented
part,
to
yeah.
the jury, was, and I'm quoting here, defendant in writing prescriptions knowingly and intentionally distributed the drug outside of the usual course of medical practice, generally recognized and accepted in the United States, and not for a legitimate medical purpose. And so the jury instructions specifically tie the knowing and intentional mens rea to Dr. Robinson's practice of medicine and the legitimacy of the medical purposes.
Okay.
So we do believe that comports.
Thank you. And you said they haven't raised it. I just wanted to.
Unless the court has any further questions, we'd ask that you affirm.
Thank you. Mr. Metztitz, we'll give you 2 minutes for rebuttal, please.
Thank you, Your Honor. I just have a few brief points to make on rebuttal. I'd like to start with where you ended with the government, which is Ruan. We are not arguing an instructional error here. We're arguing centrally that the Brady issue is that there was important evidence that went to that central element, which everyone agrees was central, that was suppressed. And in fact, in Ruan itself, Section 4 of the majority opinion notes that the jury instructions told the jury they needed to find knowing and intentional conduct. And so the question here is, well, did the suppressed evidence undercut the jury's ability to fully and fairly weigh that? I want to make a few other points.
Sorry, I want to let you make your points, but can I ask a question too on
Of
this?
course, Your Honor, it's your time.
They're yours too. So the government's argument is, all right, so the content of the DEA report and in particular CCN report differed. And you've argued about the value to, in your view, but what is your argument that the delta between that content? So as the DEA report just said, you know, Bill Pusher reported by Dr. Robinson. How do we determine that that delta, which is not stark, it's there but not stark, that itself is material?
So, Your Honor,
Would
I
have changed
think,
anything?
I think that the delta is significant because the CCN report, I think, is clearer about how Robinson detected and then reported and took his prescription back in the presence of officers. To the extent the DEA report kind of contains...
Wait, took his prescription back in the presence of officers?
Yes.
Why would he have given the prescription in the first place? I mean, that factors
Well,
into
because
it.
at that point, he did not realize that she was a pill seeker. But as soon as he was aware, he stopped treating her, he reported her, and he took his prescription back. I mean, to the extent that I think the court is struggling with some of these materiality issues, I think it's exactly as Judge Sentelle said, all the way back to Stevens, which obviously my firm feels very strongly about. The court's instinct here has been that when there is a difficult question, when something about the evidence needs to be weighed, the jury is the best party to weigh that in the first instance. And that goes to a point that I wanted to make respectfully, which is that, there was a lot of discussion, obviously, of government diligence or how they located or failed to locate issues. The law is quite clear that ultimately even an innocent Brady violation by the government remains a Brady violation. And it's also undisputed on the record that the defense asked for this multiple times before and throughout trial. And, the key thing is that the jury never heard this evidence. I also want to move to the prior...
I'll let you make the point, I promise, but I was just curious about this whole post-trial discovery thing anyhow. Why was the defense seeking discovery, and how did it happen that
So
you
Your
have to
Honor,
ask now, for, again, after trial for this information?
so I agree with my friend on the other side. I think that the government's letter disclosing the prior report is at A189, and it describes kind of the repeated requests. I think there were 8 requests. There was a post-trial hearing in, I think, February 2018, and the defense, again, kind of propounded its request because it knew these records had to exist. You know, it's simply unreasonable that there are no records of these reports. You know, we focus a lot on the CCN report. I do want to emphasize that in our view, the prior reports are very significant. And this is another way, Your Honor, that it ties specifically into the indicted patients, is if you look at the prior reports are all about pill seekers from Southern Maryland, specifically pill seekers from Southern Maryland who were coming in and you know, obtaining pills under false pretenses. And all the indictment patients were from Southern Maryland as well. So it creates, again, this kind of one-to-one matchup where the jury could really have strongly inferred that had Robinson been aware that the patients charged in the indictment were pill seekers, he very likely would have reported them. And therefore, he very likely was not aware. I want to close by emphasizing that the case law is extremely clear that Brady error is not a sufficiency of the evidence question. It's, would the jury have, in essence, struggled with this evidence? Would it have weighed on their consideration? I think it clearly would have. I think it clearly would have weakened the government's case and therefore is material. You know, there's no harmless violation of Brady, really. You can't find a Brady violation, but then hold it harmless. What you'd instead be doing is saying, well, there was no violation because the evidence was not material. And respectfully, we think that for all the reasons we've raised in the briefs and we've discussed here today, we think the clear conclusion is that the suppressed evidence was material, and we respectfully request that the court vacate Dr. Robinson's convictions accordingly.
Thank you very much. The case is submitted.
Thank you.
Case number 22-5068 et al. Janie Schieber, appellant, versus United States of America. Mr. Schreiber for the appellant, Ms. Mahan for the appellate.
Good morning, Your Honors. May it please the Court. I'm Noam Schreiber. I'm here together with my colleague Mark Zell and Steve Rod. We represent the appellants in these consolidated appeals. I'd like to reserve 3 minutes. I'd like to split up my discussion today into 2 parts. First, I'll briefly discuss what we assert as the incorrect application of the APA by the courts below, by the 5 district courts below, 5 judges below. And concluding, I will discuss why we posit that a more correct standard, correct application of the APA would have led to a different conclusion.
The real question to begin with is whether the district court had jurisdiction at all.
Well, yes, many of the district courts, several of them, 3, are ruled that there was a lack of jurisdiction under the political question doctrine. However, I will relate to that, but the underlying theory that all the district courts applied in dismissing the case that the treaty itself did not provide for a private cause of action. Some district courts found that fact results in dismissal under 12B1. Some of them found that fact results in dismissal under 701A1. However, that type of analysis for APA review in our position is incorrect. We know, for example, that APA review.
What is it you say the district court had jurisdiction to review? What statute is telling us that the district court had jurisdiction?
Well, statute is 1331. That's the statute, the underlying statute of jurisdiction.
And what is the language in that statute you say gives jurisdiction over this country?
That the laws and treaties of the United States, that as long as the cause of action rests in a law and treaty of the United States, a jurisdiction rests. And no district court ruled that there was that jurisdiction was lacking under 1331. The district courts that did render a decision on jurisdictional grounds ruled that these claims were barred under the political question doctrine. Again, though, they applied this analytical framework that is fixated on the status of the agreement under domestic law, and they focused on whether this agreement whether it was self-executing or whether it provided a private cause of action. However,
the analytical framework is muddled in at least two respects that I can see. One is people speak loosely and confuse the concepts of non-self-execution, no private rights, and no cause of action. Another is the debate over whether the political question doctrine and treaty questions go to jurisdiction or the merits. But putting all of that aside, Holmes versus Laird still specifies a rule of decision that if the treaty or executive agreement itself forecloses review, the courts shouldn't review. And we can debate till the cows come home whether that's jurisdictional or merits, but what undercuts that rule of decision such that we just wouldn't apply it? You know, at most we say, well, we thought it was jurisdictional, but it really goes to the merits, which is something we've done all the time as courts get more rigorous about classifying things as jurisdictional or not.
I have several responses to that. My first is that Holmes versus Laird did not involve a APA act. The plaintiffs in Holmes versus Laird were bringing their claims directly under an agreement. Nothing in their claims were based on the APA.
It said judicial intervention is foreclosed.
Sorry?
It said judicial intervention is foreclosed.
Yes, it did say that. But again, the APA was not invoked in that case. And in Holmes versus Laird, this court commented towards the end that had plaintiffs there formulated their claims differently based on certain actions that the United States took upon themselves in executing that agreement, the result would have been different. Holmes versus Laird specifically left that question open and discussed whether what would be the case, for example, if plaintiffs brought their claims on how the United States acted in executing that agreement. It's towards the end of the agreement, end of the decision, I'm sorry. And that's very similar to what we're doing here in these cases. The plaintiffs are not bringing any claims that the U.S. government violated the treaty. Plaintiffs are bringing claims that post-execution, as the government began adjudicating individual claims, the decisions were not based, were arbitrary and capricious based on the facts and the record. That is not what happened in Holmes versus Laird.
You are therefore relying on the APA, right?
Correct, Your Honor.
Now, if we are looking to the APA as opposed to the treaty clause to court jurisdiction, it requires a final order for us to be reviewing. Is there an order here in the sense used in the APA?
Yes, Your Honor, there is a final order.
What is the final order we're reviewing?
Each plaintiff received a written final order by the agency, by the State Department, denying their claims.
That's not an order issued carrying out the laws of the United States. As Judge Katsas was suggesting, everything here comes out of a treaty. You don't have an order of the sort contemplated by the APA, do you?
Respectfully, I think the APA does not carve out an exception for an order of an
No, it doesn't carve out an inclusion. I don't think it's included. I'm suggesting it's not including what's done in the course of carrying out a obligation of a treaty obligation as opposed to making a decision, an order decision concerning the laws of the United States.
This case is very unique in the fact that the State Department did not just make this order in a vacuum. It implemented this agreement in a very detailed manner. It created forms, its own forms. There are certainly internal policies, the administrative record has not been filed in this case, so it's hard to discern. But this is not like any other case that has, and my research, I have not found anything similar to this type of action. And therefore, our position is that this decision by the State Department is a final agency action subject to the APA, and the government has not raised this issue. The government has not claimed there is no final agency action. In fact, no one, I see I'm running into my time here, but no one, not even the courts.
Government's not getting to
The district courts did not say that the APA, the elements of the APA, final agency action, and aggrieved plaintiff was not satisfied. Instead, the district courts
I don't think the government has ever conceded that the APA is applicable in the sense of.
I'm sorry, Your Honor?
I don't think the government has ever conceded that the APA grants this review.
No, the government has not, however, raised any argument that the essential elements of the APA cause of action are not satisfied here. The government, and even more so on
That isn't the issue, whether they're satisfied or not. Why would the government raise that when the government is saying that it's not subject to review under the APA?
I agree with that, Your Honor. You're right. The government has held their position. The government's position, and even more so on appeal, is that issue should not be reached. That there is a more fundamental issue in the fact that the agreement does not create a cause of action.
Yes.
And that you can't use the APA to end run that limit on the
Yes, Your Honor.
executive.
They rely, yes. The government and the courts below rely on this court's decision in Nicaragua that ostensibly holds that the APA can't override or bypass this issue. However,
Nicaragua was before Steel Co.
I'm sorry, Your Honor?
Nicaragua was before Steel Co.
Correct. But
Nicaragua, and Nicaragua was very distinguishable in a lot of ways from this case, but as far as the passing over the jurisdictional question, Judge Mikva wrote that before Justice Scalia wrote Steel Company, saying don't pass over the jurisdiction.
That's true, and if you look closely at Nicaragua, it does not stand for the proposition that the government is offering. Nicaragua states that it does not discuss private causes of action and that the agreement needs to contain a private cause of action. Nicaragua has very specific language that the APA review needs to be based on domestic norms. And the sole authority in Nicaragua for that proposition is an administrative law treatise by Davis, chapter 28, I believe. That treatise itself, that chapter is under 701. It's discussing reviewability under section 701. It's not some abstract principle or categorical exception to APA review for international agreements. The government is correct that in its latest filing, our supplemental authorities, the government is correct. There are many of these executive agreements. But we are not asking here that there's some categorical review, permission for APA review on executive agreements. This case is very specific. I could not find any case where this fact pattern, where there's such specific implementation of specific judicial adjudication of individual applications, which should be subject to APA review.
You don't have, as far as I can tell, you don't have a single case in which the APA has been used as a vehicle to adjudicate compliance with a treaty or an executive agreement that creates no judicially enforceable rights.
Yes, it was difficult finding a case like that. I would concede, however, there is some case law suggesting that judicial APA review is available to challenge agency actions pursuant to executive orders.
I mean, you have a law review article.
And a law review article. And I will mention this.
And on the other side is Holmes, Nicaragua, Delatorre.
Yes.
I mean, a fair amount of authority.
Okay, yes, they have that. Delatorre, however, again, in our view, misapplies Nicaragua in making this categorical exception to APA review when the international agreement or executive agreement does not provide causes of action. To rule on, to make such a categorical exception, just to immune agency actions for every for every decision they take under an executive agreement, these are thousands of agreements out there.
Well,
And again,
I'm curious is because I get that the agreement is non-self-executing. But Congress has executed it. In 22 USC 2668A, Congress has executed by law a process for these agreements when there is an agreement where a foreign government deposits monies into the U.S. Treasury and an agency, here the Secretary of State, normally the Secretary of State in international agreements, I would assume, has an obligation to make payments that are due to claimants. And so I'm not sure why we're spending all this time focusing on this as if it's just an agreement that's never been executed. This one has been executed. And so then it would seem to me your argument would need to be that the APA review is on the statute that executed the agreement. That would certainly be a commonplace use of the APA. But you haven't argued that here. And so I'm trying to understand what I'm misunderstanding.
We haven't articulated the argument in that fashion. However, in our briefs, we do emphasize the fact that the agency has implemented this agreement under its authority under.
No, it's implemented there, but what matters, I understand it's done its notice of rulemaking for the form, but I'm making a different point, which is that treaties are non-self-executed unless Congress executes them, and particularly ones that involve claims for money out of the U.S. Treasury. Even the Senate alone can't decide that. That requires action of both the House and the Senate through the legislative process. And you have that here. But I haven't heard any arguments about that, yet that seems to me not covered by any of the cases that are cited here, and instead covered by Supreme Court cases that have in fact exercised jurisdiction under 2668A and other statutory claims settlement procedures without any political question problem, rejecting political question limitations, and allowing people to bring legal challenges to the distribution of money where these statutes have executed these foreign claim settlement processes.
It certainly lends itself to suggest that this agreement may be
We've got a Supreme Court case, Mellon, that says lawsuits can be brought challenging the Secretary, I think it was Secretary of State there as well, distribution of funds pursuant to 2668A. And that seems right where we are. The difficulty for me is that I haven't heard any argument that that statute is what you're trying to enforce through your APA action.
The statute itself, the government, we predict, would argue this does not provide private cause of action, and we think we would still be here today.
Well, they'd have trouble since the Supreme Court has said that.
And the agreement itself would also, under this case, the Supreme Court's jurisprudence as well, would have to provide a private cause of action still.
You don't need it when an agency normally, and this is what I haven't heard here, normally if you have a federal statute that an agency implements, then the APA gives you a cause of action for challenging the agency's implementation of that statute. You don't have to look back to the agreement, do you?
I think that's pretty much the argument that we've been making in our briefs, Your Honor. It's just articulated differently.
Well, it's very much different to articulate when a statute has executed an agreement that is otherwise not self-executed.
We didn't say that the statute itself executed this agreement, but the statute was prior to the execution of this agreement. The agreement was made pursuant maybe to the statute, but if the end result is that this court feels that the actual agreement was executed, well, I think the result is the same.
Well, then I think, because normally the way the APA works is when someone says an agency action is arbitrary and capricious, as you have argued, or contrary to law, that decision is analyzed by courts by reference to the statute that authorized agency action. So what what I wasn't clear from your briefs, and I'm sorry if it's my misunderstanding, what in 2668A tells you that this action was arbitrary and capricious?
It would be hard for a court to apply any judicial manageable standard in 2668A, I believe. However, that is the importance of the agreement, because the agreement itself provides the substantive standard, I would say, to adjudicate the individual claims. Just to rely on 2668A, I believe would cause certain issues. I have to view it again, but it would cause certain issues in applying the law because it's a very broad statute.
Well, that's what I'm trying to understand is how
I'm trying to
understand how it works. So in 2668A, which is
the way we see it, we model in our briefs. I'm sorry.
Okay, I was going to say that 2668A is a statute that sort of executes claim settlements by authorizing the Secretary of State to make determinations of what to do to a claimant, and then directing the Secretary of Treasury, who's holding the money, to release the money to whomever the Secretary of State has said the money is due. That's all it says. But it can apply to this non-self-executing treaty just like it did the one in the Mellett case. But the question that I just don't know is, in doing that, does 2660, when a statute executes a non-self-executing agreement like this, does that then make the terms of the agreement itself law? Do they get imported into 2668A? Or do you just have to look within the framework of 2668A, which you said doesn't have those types of specifics?
Thank you for zoning me into the issue. I believe the answer to that is in SLUS. It's this court's decision in SLUS. I think the proper model is that, yes, we take this approach that the statute itself is the basis for the review, and it would incorporate the substantive terms of the treaty to allow for a substantive judicial review on those actions. The treaty itself would provide the court with the standards to review the claim. Like in SLUS, I believe that was a prisoner transfer treaty. The court there had no issue in seeing that the non-self-executing treaty was implemented by the underlying statute, and it applied those substantive terms without making any rulings on whether the actual agreement created a private cause of action.
Did the treaty in SLUS have a provision that said, the exclusive remedy for resolution of disputes involving the enforcement of this agreement will be between the two countries, non-judicial?
I don't recall offhand if it had that.
Because that would be incorporated into.
Correct. If
the answer is no.
If Your Honor is suggesting that this agreement is different because it does have Article 8, which is an exclusive jurisdictional dispute resolution, our answer is in our briefs, and we think that is intergovernment to government, would not apply to post-implementation by the agency.
So your position is, even if all of this executive agreement plus 2668 were enacted as a single federal statute, you don't think that statute would preclude judicial review under Article 8?
No, Your Honor, I do not.
And how does your claim here possibly not involve a dispute arising out of the interpretation or performance of the agreement?
The dispute may arise out of the interpretation of the agreement or the implementation. But again, the question is the scope. Who are the parties to that?
Your theory is that the Secretary was bound to accept the statements made in the affidavit or an form of written undertaking as to nationality or statelessness. That might be right or wrong, but it is a question about interpretation of the agreement.
Yes, but Article 8, however, does not necessarily apply, or it should not necessarily apply, to post-implementation. There can
Didn't it
easily
say
be
any dispute? Isn't that the word used? Any dispute?
Any dispute, yes, Your Honor.
Yeah. Any, there's the,
Any. And
About
our position is
interpretation.
our position is that any dispute between the governments, which can happen in a variety of situations. Take, for example, Your Honors, if the State Department
the words
never,
between the governments are not in there, right?
I'm sorry?
The word between the government is not in there.
No, Your Honor, it's not, but the clear term in our position, the clear terms of that, and that's how the parties in our positions that the parties intended for only to apply between government to government. The similar treaties, Your Honors, executed between the United States and France and Germany, although they also contained these types of provisions, but they also allowed, although not in the United States, Europe, they allowed for a appellate review in those countries. And there's no reason to believe that the State Department, when it executed this treaty, also did not, based on APA, the background of the APA, did not feel that an individual applicant would be able to challenge their decisions in implementing this agreement under the arbitrary and capricious standard.
Sluss is your best case, but the implementing statute in Sluss seems to me very different from 2668, which I think your theory has to be that 2668 implements this agreement, for reasons Judge Millett was suggesting. But I looked at the statute in Sluss, and it's quite detailed. It specifically authorizes the Attorney General to act as the authority referred to in the treaty. And it specifically incorporates the substantive standards of the treaty into the statute. And then given that backdrop, we said the statute incorporates the treaty. I mean, we don't really have any of that in 2668. It's just a direction for the Secretary. Treasury holds the money, state adjudicates whatever state adjudicates, and then there's an appropriation for the money to get paid out. Seems to me completely different.
Yes, Your Honor. The statutes are not the same. However, for purposes of the APA, there's nothing more than what 2668 requires. It's true that Sluss, the underlying statute, the authorizing statute, was much more detailed and specific to those agreements. Although even in Sluss, it does not discuss the individual treaties. I mean, it gave broad authority to execute these treaties. It didn't discuss that specific treaty, which I believe was between the United States and Canada.
The statute is not specific to that one treaty, but it incorporates treaties, specifically incorporates treaties like that. There was one with Canada and one with Mexico.
And again, I think for purposes of APA review, for getting past this what the government considers a threshold issue, nothing more is needed than the government's own actions in implementing it pursuant to 2668A. It shouldn't be anything more that's required for purposes of APA review. That is our position.
And you think a bare bones statute like 2668, just making the appropriation and assigning responsibilities between state and treasury, can sensibly be read to override? Suppose we think Article 8 would govern if it were in a statute. Do you think 2668 can sensibly be read to override that preclusion?
It's not just 2668A. It's the whole program that the State Department implemented. It didn't just start doing this in vacuum. It implemented a whole adjudicated process to determine these claims. It created forms. Again, the administrative record is not before us, and it was not submitted in the district court. But there were internal policies. There must have been internal policies how to implement this. And this is, for APA review, this would have been more than sufficient to give the district court, standards of review, how to adjudicate this properly.
And in adopting the form, the processes, the decision-making roles and authorities internally, whatever they are, that was part of how the United States performed its duties under this agreement.
Sorry?
That was part of how that's part of how the United States performs its duties under this agreement, is developing that whole scheme.
Yes, the agreement specifically calls for it.
Right. Any further questions? Thank you very much. Appreciate it. We'll give you some time for rebuttal. Ms. Mohan? I'm very sorry to do this. Can I just ask you, if I didn't,
Of course,
if I missed it, please tell me. I didn't see the words political question anywhere in your brief. Did I miss it?
Your Honor, you did not. We are not contending that there is a political question presented in this appeal. And the reason for that is that as plaintiff's argument in oral argument and their reply brief has clarified, we take their argument, the only argument they're making, to be that the terms of this agreement were somehow domesticated or incorporated into U.S. law, and that is that U.S. law that they are attempting to enforce under the APA. And we don't think there's a political question implicated in addressing that issue, which is sort of well within the judiciary's traditional exercise of authority and implementation.
You
Thank
did
you.
ask,
Sorry to start you off without letting you get your first word in.
jurisdiction comes first. You did ask us to apply Holmes versus Laird,
Your Honor,
which is cast as a political question case.
Your Honor, it was not clear at the outset of this case whether plaintiffs were, for example, challenging the terms of the agreement itself, challenging the State Department's implementation of that agreement, the wisdom of the criteria it developed. But we think it's made clear in the reply brief, as I mentioned in response to Judge Millett's question, that the only claim that plaintiffs are pressing now is that the terms of the agreement have been somehow incorporated into U.S. domestic law. And as we said, we think that the judiciary has the tools to answer that question. And that doesn't sort of squarely implicate what was at issue at Holmes, which in that case, the court was being asked to consider whether West Germany had violated the terms of an international agreement and whether that violation in turn relieved the United States of its obligation to comply. So we think the question is framed slightly differently in plaintiff's reply brief and plaintiff's presentation here today.
You do seem to be in your brief running away from us deciding jurisdiction as opposed to deciding 12B6. The district judges, some of them at least went both ways. You're not abandoning the notion that we don't have jurisdiction because of political question, are you?
Your Honor, I think the claims as elucidated through plaintiff's reply brief and here today, we think are a different set of claims that don't implicate the political question doctrine at the outset in the complaints and in the district court proceedings.
So you are walking away from it? In this, given the nature of their claims?
In this appeal, yes, Your Honor, as those claims have been clarified. In the district court, as I stated, I think there was some confusion as to whether plaintiffs were challenging what precisely their theory was, whether they were challenging the implementation of this agreement in the abstract, whether they were challenging the wisdom of the terms in the agreement, and all of those may have presented political questions and would have been more squarely within the terms of.
So you are now abandoning the political question position?
Your Honor, we think the issue presented on appeal to this court is not a political question.
Do you disagree? Put aside the label political question. Do you disagree with the statement of law in Holmes that if the treaty itself provides for an exclusively non-judicial mechanism of enforcement, then the courts can't review questions subject to enforcement and application and interpretation of the treaty?
Your Honor, I don't disagree with that concept, and I think that that concept has been elucidated over the years in cases like Medellin from the Supreme Court, cases like Rodriguez from this court, all of which discuss this idea that when there is a specific non-judicial or diplomatic recourse that's specified in an agreement, that's powerful evidence that the parties that entered into that agreement internationally did not intend to incorporate its terms into domestically enforceable law. And,
sorry, keep interrupting when you want to say something.
No, it's okay, Your Honor. I was going to turn to sort of the theories that plaintiffs have for how the terms of this agreement were incorporated, but
Well, the other thing that your brief doesn't cite anywhere is 2668A, which seems to me to be sort of this across-the-board execution of otherwise non-self-executing agreements about sort of foreign claims to money deposited in the U.S. Treasury. So when the U.S. does an agreement and does it in common with lots of different countries in lots of different situations, it executes it. Now, as Judge Katsas has said, and just looking at the statute itself, it seems to do so only in the very narrow sense. Or what it most obviously does first and foremost is execute in the sense that nobody can pay money out of the Treasury unless it's authorized by statute. And it certainly authorizes that and authorizes Secretary of State upon identifying a claimant that's due to have the Secretary of Treasury release it. Secretary of Treasury doesn't get in trouble for releasing money to these folks. That's at a minimum, that's what the statute does. So we're not dealing with we're dealing with a non-self-executing agreement that has been executed. And your whole brief was just all about non-self-executing agreements and didn't ever grapple with the fact that it was executed. And what seems to me the difficult question here is, and it's hard to tell a whole lot from the Supreme Court's decision in Mellon, what 2668A does when there's an agreement for that it executes. Is it just this appropriation authorization, or does it allow, does it somehow incorporate substantive, when it talks about claims due by the Secretary of State, does it somehow bring the agreement into 2668A? Because Mellon was confusing. The statute said pay company X, and the Supreme Court said, well, you have to pay company Y. So there should be some interpretive stuff going on there. So one, I'm trying to figure out how your arguments map onto, at least what I think is the proper legal framework. And then the second question is, if we bring it all in, then presumably that would bring in the exclusive review. But if we don't bring it in, then it doesn't bring in the exclusive review position, and then we're trying to discern from Mellon how much review of what the Secretary did is allowed.
Your Honor, we don't think that 2668A incorporates the substantive terms of this agreement. And we think SLUS is a very helpful case on this point, because there you had a statute, the Transfer Act, that was enacted 3 months after the United States entered into this treaty with Canada. It specifically referred to the types of treaties that were at issue, and it imposed relatively detailed standards for how those agreements should be complied with. And I think that is not at all what we have here. 2668A was a part of the State Department's organic statute enacted in the 1800s. I believe, and it doesn't say at all in its terms that it intends to incorporate the substantive standards of any international agreement that thereafter is entered into. And I think it's helpful to take a step back and think through some of the context.
Well, so then it doesn't carry forward the preclusion of, or the exclusive review provision either. It doesn't give effect to that either as part of it. I mean, it certainly gives effect to the agreement, at least in making lawful the distributions that the agreement authorizes, and only those that are due under the agreement. So at least that much is brought in. But I guess the government's position is that even though it brings in the ability to make payments, there must be someone to whom payments are due, and the Secretary of State determines it. It brings that part in, but it does not bring in the review provisions, exclusive review.
Your Honor, it's our contention that it doesn't bring in any of those substantive standards. And as to the dispute resolution provision, I just think that's independent evidence that the agreement itself is not somehow imported into domestically enforceable law. And I think context is helpful here. The United States and the State Department regularly enters into these types of claim settlement agreements. It's done so recently with respect to Sudan, with respect to Libya, with respect to Iraq. And in some of those cases, Congress has, after those agreements are entered into, enacted specific statutes that implement those agreements, that impose additional procedural requirements on the State Department in undertaking to comply with its commitments. So the Sudan Claims Resolution Act is an example of that. And that's just not the case. That's not what we have here. Congress is aware of this agreement with France, and they've not enacted a statute that imposes those kinds of constraints on the State Department's exercise of its.
So how do we think about this agreement? Because if there were no legislation at all, it's non-self-executing. No one seems to disagree about that. And it seems that clearly from the face. And now you have a statute that has certainly executed it a little bit. And I wasn't sure of how, I had always thought either you had three options: self-executing, non-self-executing, and no legislation, or non-self-executing, but then executed by legislation. And it sounds to me like you're saying there's door number 4, which is non-self-executing, but a little bit executed by legislation. Is that what we would have to find?
Your Honor, I don't think necessarily. I think a statute like 2668A shows that the president might have the power to create domestically enforceable law via this agreement if he chose to do that. But I think, as Your Honor mentioned, the terms of this agreement make clear that it is not to be imported.
Sorry, I'm misunderstanding you something. You think 2668A authorizes the president to create domestic law?
Your Honor,
Is that what you said?
To be more precise, I think, as an example, if the State Department had chosen in this case to promulgate notice and comment regulations that said, here is how we plan to distribute the funds, here's the criteria we plan to use, then we think plaintiffs could bring a claim that said the State Department violated those regulations, because those would be pursuant to the State Department's statutory authority to create rules, and then the plaintiffs could then allege that
An APA challenge to that.
Correct, Your Honor.
But if they wanted to bring an APA challenge to the notice provision, it was just something, you don't offer it in Braille or something for people who have visual disability, that they might be able to, that they could do.
That's correct, Your Honor. The Federal Register notices that are referred to in the plaintiff's brief were pursuant to the Paperwork Reduction Act. So if plaintiffs were alleging, for example, that the State Department had violated that statute, that is an existing part of domestic law. If there are no further questions, Your Honor, we ask this court affirm.
Thank you. Mr. Schreiber, we'll give you 2 minutes.
Just two small comments. First, it appears from the discussion here today that the main issue, how we presented in our briefs, is the status of this agreement might have.
Sorry, you want to?
I'm sorry.
Put the mic up.
Yeah. I think what the discussion here this morning highlights that the main issue is the status of this agreement under domestic law in light of Section 2668A. And as Your Honor was discussing before, the question really is what happened to this agreement in light of that statute. One way to look at it is that it became a fully executed agreement, but that is not the only way to look at it. It could still remain non-self-executing, but subject to APA review. That is, these are essentially the same issue. The same result would happen in terms of our clients' beliefs being sought, that APA review would be available. So I don't think that there is a fundamental difference between the two ways to articulate what happened to this agreement as a result of this statute.
I'm sorry, so just to be clear, your reading is that 2668A domesticated this agreement enough that it's subject to APA review.
Correct, Your Honor. That is exactly what we are.
And what did
doing here.
2668A suggest that?
Well, 2668A provides the State Department to allocate funds in accordance with these international agreements, in accordance with the.
It doesn't say in accordance with the agreements at all. That would help me understand.
In accordance with criteria that it develops. It does discuss the criteria that it develops.
Mm-hmm.
And
well, just as the secretary will decide what to do.
I'm sorry?
The secretary will decide what to do to which claimants.
Yes, subject to whatever limitations it may have under the agreement or other law.
makes the APA, well, it implements it in,
Domesticates.
domesticates it in the sense that, at least it authorizes payments, as our Constitution requires. But I didn't see you argue that 2668A makes, I don't mean to step on your question, but if that's what makes the APA operative.
I think that
Okay.
I think that is essentially the argument we're making, that statute, together with the State Department's actions in implementing it, allows for APA review. That, I think, is the essence of what we've stated in our briefs and here this morning.
Okay.
Now, I just would like to relate to Judge Katsas. You asked me if there is any authority this specific pattern, and it was difficult to find such authority. But there is a district court case which specifically, I think, squarely points out the issue here, and I would just like to mention it here. It's from the District of Michigan. It's not from this circuit. Lake Pilots Association, Inc. versus U.S. Coast Guard, 2013 Westlaw 543-5048, Eastern District, Michigan, September 30th, 2013.
Is that in your brief?
It is not in our brief, Your Honor. That's why I'm mentioning it here. It's not in our brief, and the district court there points out there was also involving an executive agreement between Canada and the United States, and the government there, like here, argued that the agreement itself was not private cause of action, and the district court ultimately didn't rule on the issue, but it pointed out that Nicaragua and De La Torre, which the government there relied upon, like it does here, may not be applicable in that case because there is some sort of statutory source. And that, it mentioned the statute there, and that statute is similar to the statute we have here. It is a very narrow, it doesn't give much, unlike in SLOS, it's not a very elaborate statute, basically an enabling statute, an authorizing statute, but provides little in terms of the substantive standards that the court would have ruled on. Again, the court ultimately didn't rule on it. It mentioned the complexity and how Nicaragua may not be applicable in that type of situation, and it's very similar to the case here.
Maybe you should send that in through a 28J letter.
I will do that after. Thank you very much, and we would ask the court to reverse remand for further proceedings. Thank you very much.
Thank you. The case is submitted.